Hello everyone and welcome to today's Mondac webinar in association with Stren Blan Partners, who will be discussing how to navigate the complexities of enforcing foreign judgments and arbitral awards in Nigeria. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Amala Omiki is the founding partner of the firm and head of its dispute resolution department. He is a distinguished legal practitioner with a wealth of experience dealing with cross-border disputes. He specializes in commercial dispute resolution, insolvency, asset recovery, white-collar crimes and investigation, intellectual property litigation, as well as general enforcement matters. Amala is revered for his expertise in advising both local and international clients on a wide range of commercial dispute matters, as he is particularly experienced in enforcement of foreign judgments in Nigeria. Joseph Sayedon is the team lead in the firm's arbitration, real estate, maritime disputes practice groups, bringing extensive expertise to the table. He boasts a robust background in arbitration and commercial litigation, with a track record of handling international arbitrations and enforcement proceedings under various arbitration rules, including ICC, DIAC, and UNCITRAL. Joseph excels in resolving disputes across maritime, oil and gas and commercial sectors. And completing today's panel is Omar Balaji Bello. Omar Balaji is an associate with the firm's dispute resolution department. His practice focuses on debt recovery, insolvency, asset recovery, white-collar crime and government investigations, crisis management, as well as general commercial litigation. Throughout his career, Omar Balaji has represented a diverse range of clients, including HNIs, foremost commercial banks, asset managers, assisting in varying legal matters, including foreign judgment enforcement, cross-border debt recovery, and general commercial disputes. Now, before we begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to get those questions in. It's now my pleasure to hand you over to Amala, Joseph, and Omar Balaji to begin. Thank you.
Yeah, thank you, Dan, for the introduction. I'll just take 2 minutes to just introduce our firm, and then I'll hand over to Joseph. So our firm, Stren Blan Partners, we're based in Nigeria, but we have continent-wide capabilities. I think what's unique about us is that we're one of the few firms in Nigeria who are intentional about the fact that we do cross-border work. So our firm does a lot of work across the African region. We have 3 offices in Nigeria. We have an office here in Lagos. We have an office in Abuja, which is the capital of Nigeria. And we have another office down the east. But like I said, we do work in various jurisdictions across Africa. It's a full service firm, and so that means that beyond dispute resolution, we have various teams who are advising on various corporate commercial matters, energy, finance, infrastructure, capital markets, private equity, and so on. So, but in our own dispute resolution department, we deal with cross-border issues arising from commercial activities, and in that we deal with asset recovery matters, we deal with international arbitration issues. And so that's why we thought it was important for us to put together this webinar to look at the complexities and how to navigate some of those complexities, because we do get inquiries from time to time from claimants, especially from foreign jurisdictions who are seeking to enforce, whether it's a foreign judgment or a foreign arbitral award, that's an award that emanated from a foreign seat, or to do asset recovery type work. So without further ado, I would like to hand over to the team lead of our arbitration, real estate and maritime team, Joseph Sayedon, to take us through the navigating the complexities as it relates to foreign arbitral awards. Thank you very much.
Thank you, Amala, for the very kind introduction and for introducing our firm. Sam, I don't know whether you're there. Please, can you put up my slides? Okay, thank you very much. Please, I hope you all can see my screen. So I'm going to be talking about navigating basically the enforcement of foreign arbitral awards in Nigeria. Now, before it starts, I want to say that arbitral awards are either commercial or treaty related. But the focus of this presentation is commercial arbitral awards, even though I'm going to make reference briefly to some bit of treaty related issues. And commercial arbitral awards is basically arbitral awards that are made out of private commercial relationships, either between parties who are private, I mean companies or entities or even individuals, or between private entities and states that are commercial in nature, as opposed to arbitral awards that are based out of a treaty dispute, say a treaty between, say, a private entity has a dispute with the Nigerian states, and that arbitral award came out of a treaty. That one is a treaty dispute. You understand that? So please, can you move the slides to the next one? Yes. So now, I also want to say that the Arbitration and Mediation Act is the principal legislation that guides the enforcement of arbitral awards in Nigeria. It is not the only one. It is the principal. There are other legislations. For instance, some states have arbitration laws, River State, Lagos State, but I've decided to pick the Arbitration and Mediation Act because it provides the most detailed and robust enforcement mechanism for arbitral awards. And before this time, we used to have the Arbitration and Conciliation Act, and that act, even though its provisions was quite laudable, but it's quite outdated, and the provisions there relating to enforcement of arbitral awards is a bit archaic in that it created a dichotomy between local awards and international awards, and sometimes these things can be misplaced. And when you go to a judge who is not very familiar with the law, or who is, for whatever reason, you may run into troubles. But what the Arbitration and Mediation Act has done is that it has streamlined the process and made it straightforward. Please, can you go to the next slide? So I'd already mentioned the fact that an arbitral award can either be domestic or international or foreign. But as I said, for the focus of this presentation, I am focusing on foreign arbitral awards. And as I said also previously, the Arbitration and Conciliation Act had created two regimes, but under the Arbitration and Mediation Act, it is now a straightforward one-track system for the enforcement of arbitral awards. Can you go to the next slide? Okay, so under Section 57 of the Arbitration and Mediation Act, an arbitral award, irrespective of the country that it is made, is deemed binding and enforceable. That is, once an arbitral award has been made, irrespective of the country where it is made, whether you can call it between parties who are Nigerians, parties who are foreign, any country where that award is made, it is binding and enforceable in Nigeria. And once an application is made to the courts, that award will be enforced. That is the law. There's nothing anybody can do about that award as far as you are able to meet some of the conditions that I'm going to mention in the course of this presentation. Now, what are some of the things to look out for in ensuring that your arbitral award is made? Before I go into that, I just want to say that there is no unnecessary procedure or a fast rule that you're required to fulfill in having your arbitral award, your foreign arbitral award enforced in Nigeria. It is a very simple process. All you have to do is to approach either the federal or the state high courts with a simple motion asking the court to recognize and enforce that award, and it will be done. It's that simple. There is no other condition that you have to fill. And that is the good thing about the Arbitration and Mediation Act, because prior to the Arbitration and Mediation Act, and of course even the Arbitration and Conciliation Act, there are all sorts of standards that you have to fulfill. under the Reciprocal Judgment Enforcement Act, you have to first try to validate the award before you now even think of enforce. So there are all sorts of clauses, and some of those laws are still existing, and that is why you, in seeking to enforce your arbitral award, it is important that you retain a legal practitioner who knows the field, so that you are not boxed into any landmine. Somebody doesn't come up with one application to say, oh, you have not fulfilled a condition that is in one law, in one place, in one treaty, in one state law, in one federal law. No, you focus on the law that gives you the right to enforce the award as it is. And as far as that is what you have come under, you used to say something in Nigerian courts that when the court is trying to rule on whether or not it has jurisdiction, it is the claimant's claim that it looks at. So when you bring an application to enforce an award, it is what you have set before the court that the court look at. It is not any objection that the other person is bringing. And that's why you have to go with those that know the terrain so that you are properly guided. Please go to the next slide. Okay, now there's one other issue that I need to mention here in seeking to enforce your arbitral award. Before this time, because of some of our colleagues who are litigation-centric, they used to come up with all sorts of objections. For instance, if you have an arbitral award, you may have to now, let's know the court that will have original jurisdiction, as they so call it, to enforce your award. And if you go to a state high court, they'll say, this matter is supposed to be at the federal high court. The subject matter is within this exclusive purview of Section 251 of the 1999 Constitution. If you go to the federal high court, they'll say, it's a simple contract. Before you seek to enforce, you may have to overcome one clause or the other. No. The Supreme Court has laid all of those things to rest in NNPC and Fontaine Engineering Company Limited. The Supreme Court said it expressly that both the federal and the state high courts have concurrent jurisdiction to enforce an arbitral award, irrespective of the subject matter of that award. However, for me as a practitioner with experience, I prefer to use the federal courts, and that is because the procedure is straightforward. And then you can then have a judge that is most likely aware of the nuances of arbitration, because arbitration has its own nuances. And those of you in this webinar, including some very senior arbitrators whom I believe are listening to, they know that arbitration has its own nuances. And if you are a legal practitioner without the knowledge of the nuances of arbitration, then there is a likelihood that you have issues. And that's why I believe in specialty. So, as I said, the Supreme Court has settled that argument that both the federal and the state high courts has concurrent jurisdiction to enforce an arbitral award. Okay. So now, what are those things that you have to look at to consider to ensure that your application to enforce an arbitral award is seamless? First of all, you need the certified true copy of the arbitral award or its original copy. It's very important. And then you need the arbitration agreement of the parties. Now, I have seen instances when parties come to, some of my colleagues, they go to file an application to have an arbitral award enforced. And what you see there is either a photocopy of an award or documents that are not supposed to be there that expose the award to all kinds of challenges. You need the certified copy of the arbitral award, or the arbitral award in its original form is sufficient. Then also, as a practitioner in this field, I advise, if you have an arbitral award that you want to enforce, give it to a Nigerian practitioner, let them look at it, so that to know whether there are any sort of challenges that anybody may want to come up with. Maybe due process issues with the award, maybe anything in the award that may expose the award to any form of challenges. And this is very important, so that you don't file, and after you have filed, they come with one thing or the other, and then you now begin to run back to see how you can rectify. This is very important. That is very, very vital. Okay, so let's go there. Can we move to the next slide, please? Okay, I have mentioned here some of the grounds that in reviewing the award to ensure that it is liable, it is good to go, as we say it in Nigeria. You want to know whether, first of all, any of the parties was incapacitated, whether the arbitration agreement is void, and whether the due process that the arbitrator ought to have followed was duly followed, whether there are anything in the award. I've listed a number of them there. If you look through the slides, you see there's anything in the award that will subject the award to any form of unnecessary challenge. Now, I also want to say that the party that you are seeking to enforce this award against, his daggers drawn. He knows that, look, if you have this award recognized as and enforced, then you have your way. So from the very beginning, he's already strategizing on what to do, how to scheme, so that he puts you in a position where you are not able to reap the fruit of the arbitral award that you have gotten. And I have been in a position where a foreign co-counsel has come to instruct me to say, look, there's an arbitral award that we are contesting. But we believe that while the contest that we are mounting against the award is happening in Paris, our counterparty will go ahead and enforce this award in Nigeria. And all of our assets are in Nigeria, so please help us. And good enough, the grounds for which they were seeking to have that award set aside in Paris was very, very genuine. So I had to step in. And if I did not know the nuances of arbitration in Nigeria and what to do to have that award not enforced pending the application to set it aside in Paris, there would have been a serious trouble. And what happened in that matter? Let me just give a brief here so that those of us who are here, company executives, you can see how important it is to be very conscious with the step you take and be very intentional about how you go about enforcing your arbitral awards, foreign arbitral awards in Nigeria. The moment you have your award, you don't have to waste any time to have that award. Instruct a Nigerian counsel to have the award recognized and enforced. Sometimes, even if you don't have, say, and this is what part of what our founding partner Amala will talk about later. Even if you don't have an asset in Nigeria, but the Nigerian party has some presence here, that they may end up using their presence here to mount a resistance to your enforcement, even in any other jurisdiction. It is important that you take a step quickly to have the court to recognize and enforce the award. That is because if you don't do that, what may happen is that by the time you are now finally ready to have the award recognized and enforced in Nigeria, they may have gone to file an application to either ask the court to refuse to set aside the award, or as some of our litigation colleagues are easily doing, even when they know that the Nigerian court has no jurisdiction to set aside the award, they'll go and file an application to have the award set aside in Nigeria, even when they clearly know that the Nigerian court has no such jurisdiction. It is just to take that strategy to take you down, so that any other step you want to take, they will be ahead of you, and that is not good at all. Secondly, there's this thing that is very important that some of our colleagues, and especially those of them abroad, they don't understand. They will be dealing with a Nigerian party, maybe have an arbitration abroad, and they will not include a Nigerian counsel in the arbitration team. And they will not face challenge when they are ready to enforce. Because, for instance, that Nigerian counsel would have helped in, and this again, my founding partner Amala will talk about it later, would have helped in clearing the ground, so that when there is time for enforcement, you then move very quickly. Then there's one other aspect that I want to mention here. And once you file an application to have an award enforced, what you see most likely is that they will go and file a subsequent application to have the award, either have the court either refuse to recognize and enforce the award, or have the court set aside the award. If they do so, as a counsel, I always advise, there's no point joining with more issues with the other party. Just ask the court. Court say they are saying that this award is not yet binding, or there's one reason or the other not to have this award enforced at this point. Let them pay the award let them pay the award into the award, the sum for which all of us are contesting into courts. And the law adequately makes provision for that. The law is very, very clear. I think in section 58 or so of the Arbitration and Mediation Act. He said when there is an application to enforce an award, and then there's a subsequent application to either suspend the enforcement proceedings or otherwise, that the party seeking to have the courts enforce the award is entitled to ask the court to ask the other party to pay the award sum into an interest-bearing account under the court supervision. And the other party did not provide that security, then they are not even entitled to be heard. That is the law. Okay. So now I was also going to mention about statute of limitations, but I've just covered that already about the need to move very, very quickly. So please move the slides. Okay. Now, I've mentioned this one in passing, but I just want to reemphasize. The law allows the award debtor to have the court refuse to recognize and enforce the award. That is the law. That is the right that the law gives to the award debtor. But that is not at large. The grounds in which a foreign award, an award debtor can seek the court's support to have an award, to seek the refusal of the enforcement, the recognition and enforcement of an award is streamlined. And that is where I want to talk about the New York Convention. Now, the Arbitration and Mediation Act has domesticated the New York Convention. And in Section 60, it is very, very clear there that the grounds in which a foreign arbitral award or a court in the contracting states can refuse the recognition and enforcement of an arbitral award is streamlined. It is not on any grounds. No, it's not on any grounds. Those grounds are streamlined to about 4 or 5 of them. And if those grounds are not specifically mentioned, you can't just come up with, for instance, there's a misconduct of an arbitrator in England, or there's a due process issue. If those grounds are not clearly specified, then the court has a duty under the New York Convention to have that award recognized and enforced. It is very, very clear. It is very, very clear. So those are part of the things that you have to consider, and that's why I always advocate that before you go about your enforcement proceedings, give a counsel to have the award reviewed and see whether there is any challenge that you can probably anticipate. It's very, very, very important. Okay, you can move the slide. Sam, are you there? Can you move the slide, please? Okay. Now, before I go to the next thing I want to discuss under this heading, I want to talk about public policy. We see that some of our colleagues who are, looking for all kinds of ways to have to deny award creditors the benefit of their award, they come up with all sorts of tactics. And one of the grounds as I listed, as I mentioned in the New York Convention, as domesticated also in the Arbitration and Mediation Act, is the ground of public policy. Now, public policy, unfortunately, is not clearly defined either in the Arbitration and Mediation Act, in the New York Convention, or so sometimes we see people come up with all sorts of grounds and weave it under the public policy ground to say the arbitral award should not be recognized and enforced. And as I said, even though the public policy is not defined, it is not at large. For instance, in one of the cases I'm aware of, this case involved a charter party dispute. And in that charter party dispute, the parties were very, very clear as to what each his obligation would be. It was clear there that, look, the person that is obligated to pay the hire for that charter party would also be obligated to pay the withholding tax. And what the respondent or the award debtor simply did in coming to seek the Nigerian courts to refuse recognition and enforce the award is to say, look, that the issue of tax is an issue that arbitration cannot be determined in arbitration. And so the arbitrator was wrong to be awarding tax liabilities to them as a party to that arbitration. Now, there are Nigerian authorities that have, dealt with more clearly focused tax issues. And the Nigerian court has said, look, tax is not arbitrable. But this party cleverly wants to use public policy and that authority and turn it on its head to come and say. But I thank God for the Nigerian courts that we have. And I was listening to one of the webinars on enforcement of arbitral awards by Chartered Institute. And the judge, one of the top judges at the Federal High Court, he said, you cannot, I'm an arbitration practitioner. I'm aware of arbitration, so you cannot come with one clever answer, one clever argument, and think you can put me up my feet. I'm a member of this field. I'm also a practitioner in this field. He said, look, the issue of who to pay tax can be agreed upon by the parties. And if the arbitrator has found the fact as to who is to pay a particular tax, you cannot come and tell me that that is a public policy issue. And I'm grateful for the kind of the judges we have in the Nigerian, especially in the federal courts now, that are in a position to see through when a party is making an argument that has no sense whatsoever. But it takes a practitioner who knows his onions to be able to know when those arguments have no sense whatsoever and to know what to do. That's very important. So you can move this slide now. Okay, so I want to conclude by saying that the Arbitration and Mediation Act has streamlined the way and manner with which arbitral enforcements are made, and that once a practitioner understands the nuances of arbitration, it then becomes very easy to guide our foreign colleagues or our foreign companies who want to have arbitral award enforced. Then, in closing, I want to say something. When it comes to treaty awards, unlike conventional awards that you have to go to either the state or the federal high courts, when it comes to treaty awards, a treaty award against Nigeria or any other country that you seek to enforce, mostly against Nigeria, especially if that treaty award is made pursuant to the Exit Act. I mean, if it's an award that is made out of the International Center for Settlement of Investment Dispute, that award is enforced as a judgment of the Nigeria Supreme Court. So all you have to do is to simply approach the Supreme Court of Nigeria to say, look, this award is final and binding, and I'm asking that this award be enforced. And it's as simple as that. That award will be enforced as a judgment of the Supreme Court. So I just had to mention that for the purpose of those of you who may have issues with treaty awards. So this concludes my presentation, and then I will take your questions perhaps either now or maybe later after all of the presentations have been made. Thank you very much.
Okay, I think Bolaji, we can take yours, and then
Thank you very much.
probably take.
Thank you very much, Amal. Hi, everyone. Yes. So today I'll be guiding us on the enforcement of foreign judgments in Nigeria, the complexities and the best practices on how to resolve some of these complexities. Next slide, please. So to commence with, what is a foreign judgment? A foreign judgment, quite simply, is the judgment delivered by a court in another country. So for instance, a judgment delivered by a court in the United Kingdom or a judgment delivered by a court in America. These are foreign judgments here in Nigeria. And the basic rule is that these judgments have no legal effect here in Nigeria. But if you look at it that way, what then would be the position of international trade, and how would people be able to freely transact between different countries? How would I be able to transact with someone, let's say in Spain, and the person would be comfortable enough to believe that if I default or fail to fulfill my obligations, there's a way in which he can get me to fulfill that obligation and duty. It's based on this line of thought, respect that certain rules have been developed under the realm of private international law that allow for the judgments delivered by a court in one country to be recognized and enforced in another country. In Nigeria, this is also the position. A judgment of a foreign judgment can be registered here in Nigeria and enforced. However, there are certain statutes that guide and regulate the enforcement and recognition of such foreign judgments. In Nigeria presently, we have 2 statutes that regulate the enforcement of foreign judgments, and these are the Reciprocal Enforcement of Foreign Judgments Ordinance 1922 and the Foreign Judgments Reciprocal Enforcement Act 1961. These are the 2 statutes which guide and regulate the enforcement and recognition of foreign judgments here in Nigeria. A third method by which foreign judgments, which has been affirmed by the Supreme Court, by which foreign judgments can also be registered here in Nigeria is by common law. And the reason for this is Nigeria definitely has a relationship with the United Kingdom and is a common law jurisdiction based on our colonial history. Please, next slide. What are the relevant laws that guide the enforcement and recognition of foreign judgments here in Nigeria? As I said earlier, there are 2 main statutes, which are the Ordinance and the Act. But aside from this, you also have the civil procedural rules of various high courts of the states, the 36 states of the Federation. You also have the High Court of the Federal Capital Territory, Abuja, and then you also have the Federal High Court. That is because under both acts, they say it's provided that to register and enforce a judgment, you bring an application to the High Court. And the High Court was interpreted to mean the Federal High Court or the State High Court. Also, for when you've obtained the order to register a foreign judgment, the next step is to enforce that judgment. And here in Nigeria, the law that regulates the enforcement of judgments is the Sheriff and Civil Process Act. Finally, as my colleague Joseph has put to us, the Arbitration and Mediation Act also comes into play here. Next slide, please. Yes. So how do these laws apply? And why is it important that we understand how these laws apply? I will borrow a word from Joseph when he said, the opponents will put landmines in place if you do not know the proper thing to do when bringing an application for registration. Both laws, that is the Ordinance and the Act, have their spheres of influence. That is, they have countries which they apply to. For the Ordinance applies to judgments from superior courts in the United Kingdom and territories or dominions under His Majesty, which it has been extended by virtue of Section 5 of the Ordinance. Some of these countries include Ghana, Grenada, Jamaica, and Sierra Leone as well. So the judgments of this country, when you have a foreign judgment of any of these countries, it's best to bring it under the Ordinance, which is the law that guides it. Now, for the Foreign Judgment Reciprocal Enforcement Act, its sphere of influence, ordinarily what it does, what the Act contains under Section 3 of the Act, it empowers the Minister of Justice to extend its operation to any country that offers reciprocal treatment of Nigerian judgments as well. However, so today, this has not yet been done, which means that part of the Act is incomplete. However, a saving provision was provided in Section 10A, which allows for judgments from other countries, aside from those countries to which the Ordinance applies to bring the application for registration. Thank you. Please, the next slide. So now, are all types of judgments registrable in Nigeria? Can I just get a foreign judgment and bring it to Nigeria and register it? The answer is sadly is no. Only money judgments are registrable in Nigeria. There are certain jurisdictions that allow you to register non-money judgments, but in Nigeria, it's only money judgments. That means that the judgments of declaratory nature are excluded from registration. What is the money judgment? The money judgment simply is a judgment where a sum is declared payable. Even if the sum is declared payable in installments, it still qualifies as a money judgment, because by simple arithmetic procedure, you can calculate how much the judgment debtor is to pay. So that's what qualifies it as a money judgment. Also, for a judgment to be deemed registrable in Nigeria, it must be a final and conclusive judgment. It should not be in the form of an interim or interlocutory judgment or orders. It must be final as to determine the rights of the parties in the original court before you can bring it down here to Nigeria and say you want to register it. Then again, before you proceed with the application for registration, a very important thing you must consider is this foreign judgment which you seek to register, does it meet the requirements of the law? If you're bringing it under the ordinance has certain requirements that you must fulfill before the court can grant leave for you to register judgments here in Nigeria. Same thing with the Act. The Act also has its requirements, and both statutes have different requirements, which we shall soon see. Please, the next slide. Let's look at the requirements of these statutes. Yes. So these are the requirements under the ordinance. Under the ordinance, there are a number of requirements. I'll just pick on a few of them. One of them is the fact that the judgment should not have been obtained by fraud. As we all know, especially the practitioners that are watching, as we all know, fraud vitiates everything. The moment the judgment letter can prove that judgment was obtained by fraud, the registration, you will not be allowed to register that judgment. Secondly, again, the original court must have acted within this jurisdiction. It must have had jurisdiction to determine that, to give that judgment. It would not have jurisdiction, for instance, in a case where the judgment is in respect of immovable property here in Nigeria. The judge or the court must have had jurisdiction to determine that cause of action between the parties. Again, another thing is, as I said, it must be final and conclusive. Under the ordinance, one of the requirements is that if there's a pending appeal, you cannot proceed with registration of that judgment. If the judgment debtor has the right to appeal and has shown intention to appeal, you cannot proceed with registration of that judgment because it affects the issue of finality. And as similar to what Joseph had discussed, there are also public policy considerations here in Nigeria. So definitely, if the transaction, for instance, that led to the judgment is illegal here in Nigeria, you would have issues. You will not be able to register such a judgment here in Nigeria because under public policy requirements, where an act is illegal in our country, even if it is legal in your country or in the foreign country, and you get a judgment based on, when you bring it to Nigeria, it will not be registered under our laws. See, please kindly, next slide, please. Let's look at the Act. What are the requirements under the Act? Similar to, like I said, the Act has different requirements from the ordinance. The Act also requires that it must be final and conclusive. There's a payable sum, but the Act also goes further to say, in respect of taxes, charges, and fines, these are not registerable under Nigeria. An application must also be made to a superior court of record similar to the ordinance. The application must be made within 12 months, and the judgment must not have been wholly satisfied for it to be able to register. So in essence, if the judgment debtor has already paid the judgment sum, what then is the point of attempting to register it within our jurisdiction? These are the requirements for registration under the Act. Next slide, please. Again, similar to in the area of arbitration, one must be conscious of the time frame for registering a foreign judgment. Presently, as I stated, we have 2 statutes, and each of these statutes states the time frame for registering a judgment. Under the ordinance, the time frame is 12 months for registration of a foreign judgment. That means you must bring the application for registration within 12 months after the date of the judgment. Even if, although the ordinance goes further to say, or such longer period as may be allowed, the problem with this is the decision to allow you to register, to bring an application to register a foreign judgment after the time frame has expired is completely at the discretion of the judge who will determine the application. And this represents a further hurdle against the judgment creditor. Ordinarily, a judgment creditor should just come into the jurisdiction and file an application to register the judgment. But here, if you do not do that within the time frame required, you now have to file an application initially to seeking an extension of time within which you may bring that application to the court. Under the Act, Section 4 of the Act says that you have 6 years to bring an application to register the judgment. However, you recall I said that the Minister of Justice is yet to exercise that power, which means Part 1 of the Act, which contains this provision, remains inchoate. However, there's a savings provision under Section 10A of the Act, which allows that you can bring such an application within 12 months after the judgment, before the minister has made such an order. So in both situations, that is under both statutes, you bring an application within 12 months. That is the safe period that you can bring the application, and you will not need to seek an extension of time or be at the discretion of the courts, be at the mercy of the discretion of the court in granting an application extending time. Please, next slide. Now, what is the procedure? How do you go about this? And it's important for you to understand the procedure because both the statute and the ordinance have the procedures. The ordinance specifically states a petition, and you can bring it by way of petition or ordinance motion when you're dealing with the Act, but the ordinance has rules, and the rule says petition. In practice, you do not want a situation where you bring it by another you don't want to bring a situation where you bring it by another method of commencing an action and then the opposing party raises objection. So it's better to bring it by a petition, which can be ex parte. And under the ordinance, the judge may, if you bring an application ex parte, the judge may order that it should be on notice to the other party. So those are the two ways. You bring it by petition or by urgent motion, depending on under which statute you are bringing the application. Now, what does this application contain? The application, similar to the enforcement and regulation arbitration report, you need a certified true copy of the foreign judgment itself delivered by the court. You need a certified true copy of the foreign judgment. And in the event that the foreign judgment was delivered in a language other than English, you need a translated version, also certified as well. So you need both copies. Both copies will be attached to the affidavit in support of the application. What does the affidavit contain? The affidavit in support of the application contain the necessary facts of the foreign judgment, the necessary fact of the parties, that is judgment creditor and judgment debtor. Judgment debtors addressed within jurisdiction. If the judgment debtor is an entity in Nigeria, you state all of those relevant facts and brief facts about how the court arrived at the judgment as well. These are the necessary things that need to be stated in the application. Again, in the affidavit, a very important thing is you must state the requirements that you have met the requirements of registration. So if you're coming under the ordinance, you have to state that you've met all the requirements under the as required by the ordinance. If you're coming under the act, you've met all the requirements as required by the act as well. Finally, you support it with a written address which contains the legal arguments. Once you're done with this, you file your application. In practice, this is an application, especially when it's made ex parte, it's an application that should be granted by the second adjournment. Usually here in practice, the judge in the first adjournment on the matter would ask to have an understanding, a brief background, to be informed of the matter before it, upon which further adjournment will be granted. And at that position, being ex parte, once you move the application, the judge would ordinarily grant it, since it's uncontested. What next upon the grant of the order to register? Under the ordinance, you have requirements for notifying the opposing party, that is the judgment debtor. The order would also state the time frame within which the judgment debtor can bring an application to set aside the registration. So you have to fulfill all those requirements, because if you do not, looking at the ordinance, especially the ordinance has rules, and the rules of the ordinance are very, very specific as to certain requirements of things that must be done before you can even proceed to registration. For instance, there is a notice that is required under the ordinance that must be given within 3 days. If you fail to do that, the opposing party will bring an application to contest any enforcement that you attempt to do. So you want to avoid all these pitfalls and little arguments in between that can be distracting and only prolong the process of enforcing your judgment. Next slide, please. Now, before we go to the setting aside grant, how do you even enforce is another question. How do you enforce a foreign judgment once you've registered it? That is, let's say the judgment debtor fails to bring an application to set aside the registration, or just lays back, notwithstanding being served and giving notice of the registration within jurisdiction. Once the foreign judgment is registered here in Nigeria, it automatically becomes of the same force and effect as a judgment of the registration court. Meaning, if you register a foreign judgment at the High Court of Lagos State, it is taken to simply be a judgment of the High Court of Lagos State, which means you can proceed to enforcement the same way normal judgment of the High Court of Lagos State can be enforced, which are, you just refer to Sheriff and Civil Process Act. You can come by way of garnishee proceedings, you can come by way of FIFE and enforce your judgment, especially when judgment debtor doesn't. But now, let's say judgment debtor decides to bring an application to contest the registration and seek that it be set aside. What are the grounds? What are the grounds? The grounds are provided distinctly by the statutes as well. This is why I keep saying the statutes, because each of the statutes has there are differences between the two of them. And when you bring an application, you have to be sure under which of these laws are you coming under. It's one of the challenges because of the dualist nature of the enforcement of foreign judgments here in Nigeria. But looking at it from a general language, the grounds for setting aside the registration of a foreign judgment would include that the original court did not have jurisdiction in the first instance, like I said, in respect of an immovable property here in Nigeria. Again, issues of non-service or lack of notice of proceedings. This is a question of natural justice, and under the Nigerian Constitution, everyone has a right to fair hearing. So if the judgment debtor was not served with the processes here in Nigeria, while it was here in Nigeria, you are aware it's here in Nigeria, wasn't set, and you proceeded to get judgment, it would, upon an application to set it aside, the court will look at it from a constitutional point of view that he has a right to fair hearing, which he was denied, and he would definitely, the judgment would be set aside, the registration would be set aside. Again, another question is where the judgment was obtained by fraud. Where the judgment was obtained is one of these limited exceptions where a Nigerian court can go into the merits of the foreign judgment to see where, especially when fraud is alleged, that the judgments were, this could be by way of maybe the documents that were put before the foreign court. However, it's not a easy process that you just claim, oh, it was obtained by fraud. A question that would arise that the judgment debtor must answer is why did you not bring notice of this fraud to the foreign court during the proceedings as at the time? So these are some of the grounds for setting aside. Further grounds are stated under Section 3 sub 2 of the Ordinance and Section 6 sub 1 of the Act as well. In practice, I have had a situation where they registered the judgment, but upon review of the judgment they registered, I realized that what they had done was they had registered interim and interlocutory judgments, and immediately I brought it to the notice of the court that these are interim and interlocutory judgments of the court, and the registration was set aside based on that ground because they had not fulfilled the actual ground for registration in the first instance. So that's also another argument you can put before the court that the actual requirements for registration were not fulfilled as well. Next slide, please. You will recall I had stated that there's a third method by which a foreign judgment can be registered in Nigeria. And the third method is by an action at common law. Why is this? We have Nigeria is a common law jurisdiction, and under the common law, a judgment gives rise, can also give rise to, is a cause of action that can give rise, because it's a debt to be paid. So in the event that maybe the time frame of any of either the ordinance or the act has expired, you can bring an action at common law by simply arguing that one, there's no defense to this because the cause of action is the judgment. You're not relitigating the issue that has already been litigated in the foreign court. You're merely bringing an action here to say that there's a foreign judgment which you want to recognize by the Nigerian court and you want to proceed with the enforcement. So on the basis that there is no defense to the judgment, that has no defense to the existence of this judgment, the best method is to come by way of a summary judgment procedure. Or better yet, you look through the civil procedures of the court where you intend to register it and confirm that it has such an application. So if it has a summary judgment procedure, you can bring it under the summary judgment procedure so that it would be basically affidavit evidence similar to the petition and the originating motion. There will be no need to call witnesses, no need to call evidence or tender evidence in court. All you need to do is attach the certified true copy of the judgment and file the action in court. The judgment debtor will also file its counter affidavit and written address, and the court will determine it on the basis of the affidavit evidence before it and decide whether or not the judgment should be registered and enforced in Nigeria. The time frame, to consider the time frame for an action at common, you have to look, it depends on the state in which you intend to register. You have to look at the limitations of that state to arrive at whether or not it is registrable there. Please, next slide. Okay, so what are the challenges? What are some of the challenges that are evidence in the system that we have here for the enforcement of foreign judgments? In Nigeria, firstly, the most notable limit is the fact that it's only limited to money judgments. Some jurisdictions allow for non-money judgments to also be recognized and enforced in their jurisdiction, but here in Nigeria, it's only money judgments. Again, as I had stated, the fact that we have two different statutes, legislation that regulates the enforcement of foreign judgments, somewhat gives rise to confusion sometimes for practitioners, not knowing under which law the application for registration should be brought, which requirements need to be fulfilled. This dualist nature has been a constant challenge here in Nigeria, and it takes a proper deep understanding of the statutes and the workings of statute, the application of the statutes to know under which ordinance, which law to bring an application for registration of a foreign judgment. There's also the argument that the ordinance is antiquated, which is true because some of the provisions of the ordinance are not in line with modern realities. An unfortunate consequence of the ordinance, which we note was in the case of Grosvenor and Alloway, where the judgment debtor could quite simply just walk away simply because he refused to appear in the proceedings or submit to jurisdiction of the foreign court. The 1990 Act presently also has the challenge that it has no rules unlike the ordinance. So the how to apply its provisions specifically have not been provided. And in practice, there are ways to go around some of these challenges, most of these challenges actually. For instance, next slide, please. So for instance, when asked on how to proceed with the enforcement of a foreign judgment, the very first thing I would consider important is an asset tracing exercise. It's important that you are sure whether Nigeria is the proper avenue to register and try and chase after the debts. So you have to carry out asset tracing activities, which would best be done during the substantive suit, so that will give you an understanding of the asset position of the judgment debtor. And what does this do? When you come into the jurisdiction, the very first thing when you're filing your application for registration, you also file within an ex parte application for a barrier injunction in order to secure those assets within this jurisdiction. Again, looking at the issue that arose from the case of Grosvenor and Alloway, another thing that can be done in practice, especially at the contractual level, where you're dealing with how at the transactional level, is that you impute jurisdiction clauses. That is, you agree to a choice of forum. This has been affirmed by decisions here in Nigeria, although you have to be careful in practice how you make these drafts. Basically, that's it. So the complexities can be addressed at the transactional level too, and you just need to engage in Nigerian counsel both at the contractual level to be sure that the contract you're entering into is within, is legally available here in Nigeria. So thank you. I'll be handing over to Mr. Amala to discuss disputes from there.
Yeah, thank you, Bolaji, for that insightful presentation. I think my two colleagues, Joseph and Bolaji, have done justice. I'll just take a few minutes to then talk about some of the innovation. Like Bolaji has mentioned, there are certain things that you consider from a commercial perspective before you want to enforce an award or a judgment in Nigeria. Not just in Nigeria, but generally in every jurisdiction, right? You have to look at, for instance, asset tracing, right? Is there assets within this jurisdiction that you're talking about? Just this morning, by the meeting with some claimants who had some claims, some arbitral awards, and they're looking at enforcing in Africa, right? And I asked which place in Africa. They told that it's not in Nigeria, it's in a different jurisdiction, but we'll still be able to assist because we work in some of these jurisdictions. So some of the issues that you find when you deal with, especially our colleagues and our friends in other jurisdictions, perhaps in Europe or in America, is that, that the fact that they see Africa as if it's one country, and then you don't do proper asset tracing within, because the sort of laws that you have in Nigeria is different from what you have in Kenya, it's different from what you have in Botswana, different from what you have in Gambia, Gabon, and South Africa, for instance. So it's important that you deal with finding assets, right? That would also enable you not to throw good money at bad, right? You're able to see assets that will be able to satisfy the judgment that you'll be able to get at the end of the day in Nigeria or in any other African country when you deal with that. Of course, as a firm, one of the things that's unique about our dispute capabilities is that we have an end-to-end offering, right? Which means that we also have the internal capabilities to offer asset tracing services. We do not outsource our asset tracing capabilities. We have a standalone asset tracing and investigation team that will be able to do that and also present an opinion as to the commercial and legal viabilities of such an enforcement before that is done. Now, one of the issues that we, dealing with cross-border disputes and international disputes that you always reckon with, especially when it comes to perhaps arbitration. We see that quite a lot. And for some of us who might be listening, and you probably for younger practitioners who just left school, one of the things they will tell you in arbitration is that it's more, or it's less expensive than litigation. You'll be shocked to know, especially when it comes to international big ticket disputes, that's largely not true, right? It can be very expensive, and not just arbitration, but litigation and disputes generally can be very expensive because they can be long, they can draw out, and like Joseph Akopolaji had said, you are dealing with another party who would pull out every trick under the hat to ensure that they frustrate whatever thing that you're about to do. So one of the key decisions that, or key factors that one will potentially look at is the issue of funding, right? We want to know how you'll be able to fund this dispute or fund the process of enforcement in Nigeria, for instance, right? When you have these opportunities arising, or when you have these claims arising within Nigeria. Please, next slide. So what we want to do is to look at an understanding of what dispute funding is, right? Most of the time, we've seen that happen, especially with some of our foreign friends and foreign colleagues. You might have a claimant who would have a claim in Nigeria and who would want to pursue, for instance, an arbitral proceedings. And because the person is not familiar with the jurisdiction, would not want to pursue those claims, right? Because to that person's mind, the person doesn't understand the nuances of how these things pan out, and wouldn't want to spend monies engaging lawyers, engaging practitioners, engaging investigators in order to be able to pursue these things. So on the basis of that, you then find the importance of dispute funding or third-party funding within this context. Next slide, please. Now, dispute funding or third-party funding, right, is that sort of arrangement that allows a third party, an independent third party, to fund the proceedings or the expenses, the fees that will be incurred by a claimant in respect of a particular matter. Oftentimes, the incentive for the funder or the third-party funder would be that the funder would then take a piece of the pie at the end of the day when the claimant becomes successful. So it's, in some instances, the risk is shared, right? So let's say it costs probably $50,000, $100,000, $200,000 to pursue a claim. And you then have a third party who is able to say contribute up to 60%, 70%, or in some cases 100% of the fees or the expenses that will be incurred in pursuing that. So one of the things, especially when you deal with arbitration, there is one that I know that Joseph and his team is dealing with, and the client got the fees back from the arbitration, a very good claim, and he said, I'm not sure whether I want to proceed, the fees is a bit prohibitive, right? So that's typically some of the concerns, and you see instances where you have very good claims not being pursued because the corporate or the individual behind the claim does not have the resources in order to be able to pursue that, for instance, pay arbitrators fees or pay the fees of counsel, depending on the sort of disputes that you are handling. So third-party funding generally all over is a system that allows third parties to be able to then fund these sort of disputes. And like I said, the incentive is that the person is able to then take a piece of the pie, that's a third-party funder, at the end of the dispute, especially where you then have a successful claimant. In Nigeria, historically, because we are fashioned, and I'm sure having listened to Mobility speak extensively on the ordinance and on the common law method of enforcing judgments in Nigeria, we borrowed our laws from England, right? We're a common law country. And so the common law rule as to champati and maintenance, which prohibits funding of disputes in a very plain vanilla sense, ordinarily applied in Nigeria, such that third-party funding was prohibited in Nigeria completely, right? It would be seen as champati and maintenance, and that would vitiate a proceedings, right, under public policy, if such is allowed. In England, of course, that has changed, right? Although there were some spanners that were thrown by the Supreme Court decision in England on third-party funding, but that's in England. Thankfully, in Nigeria, last year, under the new Arbitration and Mediation Act, which Joseph spoke extensively about, the law under Section 61 of the Act expressly excludes the application regarding the rule of champati and maintenance. It says that it no longer applies, or it shouldn't apply within the context of the law. So what does that mean? That means that that common law prohibition that had inhibited third-party funding in Nigeria was excluded by the Act last year, and then that allows third-party funding to now come in place in Nigeria. So that is good news, and we feel that that is something that now makes Nigeria an attractive jurisdiction in order to be able to pursue claims ordinarily where a claimant would, for various commercial reasons, either out of the fact that the person does not have the resources at all, or the person does not feel that he would want to carry the risk. When I mean person, I mean corporates, for instance. Then you are then allowed to get a third-party funder to fund the dispute, and that will no longer be prohibited in Nigeria under the rule of champati and maintenance. Sorry, next slide. Next slide, please. So, like I said, that is now allowed under Section 61. Doesn't apply again in respect of any arbitration or any arbitration-related proceedings in Nigeria. And so you can get a neutral or a third party to fund your disputes, and that will be allowed in Nigeria. Next slide. The law then makes provisions in respect of what you are expected to do where you have a third party, and basically these are just disclosure requirements, right? These are disclosure requirements. You have to give notice when you have a third party funder who is funding the proceedings. You have to give notice of such third party funder to the arbitrator, to the other parties, or to the arbitral institution or tribunal. And then you are also meant to provide the details of the funding arrangement and the funder to the respective parties. So basically, these are, again, plain vanilla requirements. These are mere disclosure requirements that in order to be able to make the entire process of funding transparent. Next slide. And lastly, I think it's important for us to be able to note the sort of potential that we now see with third-party funding in Nigeria, right? Like I said, one of the issues that most claimants, or some claimants at least, will typically have is being able to fund a dispute, especially for corporates where you have limited cash flow, or where you are, let's say, the legal department of a corporate, you have very limited budget, you need to be able to manage the budget, and then you have the management or the board breathing down your neck as the legal director or head of legal or company secretary to bring down the budget, that the budget is over, ballooning by the day. The third-party funding structure allows or presents an avenue for you to be able to remove the fees or remove the expenses that ordinarily the claimant would have incurred in pursuing these disputes, and then remove it from the balance sheet of the company and move it to an independent third-party funder, right? So it allows corporates to free up their budgets, for instance. And then secondly, of course, is that the issue, especially when it comes to foreign claimants regarding risk, right, which is the good old saying, throwing good money at bad. You're not familiar with the jurisdiction, you do not think that you will be able to fund the arrangement, not necessarily because you don't have it, but because you're not familiar with this jurisdiction, and so it's a risk for you to pursue the claim in that jurisdiction. What third-party funding does is that it takes care of that risk. You probably talk to a third-party funder who is familiar with the jurisdiction, and then it takes care of that risk, and then it allows you to pursue your claim. So we think that with the advent of third-party funding, there would be the avenue for foreign claimants and foreign investors to come in, knowing fully well that if there is a dispute, they will be able to get the sort of funding that is needed in order to be able to pursue their claim. Next slide. So generally, right, we think that in terms of, and because of the nature of third-party funding, it allows you to not just look at the proceedings itself, but also the issues ancillary to it. So things like asset tracing, being able to determine in terms of where the assets are, right? You're able to use the resources that is available under the third-party funding mechanism in order to be able to remove the risks associated with even those initial inquiries that you would like to make before you get into the main nitty-gritties, which is the proceeding itself. As a firm, what we've done is that we've been able to we have extensive experience working with third-party funders, and we've also been able to help promote a third-party fund that allows foreign claimants to make such claims in Nigeria. So for some of our colleagues who are listening in and who would be interested in knowing about the fund that promoted, myself, Joseph, and Bolaji would be more than happy to have a private conversation to look at specific claims and how that works. Thank you very much.
Thank you very much, Amala. And before we end today, I would just like to extend our thanks to Amala, Bolaji, and Joseph for your incredibly informative presentations today. We really appreciate your time and your thoughts and your experience. We hope we can have you back again soon. Thank you very much also to our audience for being with us today. We really appreciate you being with us. So I hope you all have a lovely rest of your day. Thank you once again to our panel for Stren Blan. Contact information is there in front of you. As Amala says, please do get in touch if you have any questions. So brilliant. Thank you very much, everyone. Have a lovely rest of your day. Goodbye.
Thank you.
Nice.